Mr. Menashi, you have been subject to an unusually vicious, unusually personal, unusually vitriolic series of attacks in the media, including by TV talk show personalities, who said things like, you support and have made arguments for, made excuses for a highbrow or made a highbrow argument for racial purity. That's a quote. As a Jew, as a survivor of persecution, given your family history, do you want to speak to that? I mean, how does that make you feel? How do you respond to that? Are you an advocate for racial purity?
No, Senator, I absolutely am not. I abhor discrimination. I value this country's traditions of tolerance and equality before the law. As I said in my statement, it's very personal to me because my family has suffered persecution and victimization on the basis of our ethnic and religious status. And so it's hurtful, and I think it misrepresents what I have written in my particular concerns when those kinds of charges are levied.
It's really quite extraordinary, I have to say. I mean, I've never seen it quite like it, to be accusing you with your history and your family of being basically one step away from a Nazi. I mean, it's really something. So all I can say is I'm sorry that this is what you have to go through to be nominated to serve on a court as a judge in this country, and particularly given your family's history, it's really something. So I'm sorry that it's come to this. I think you have acquitted yourself quite well. Let me ask you about a different subject that I'm concerned about. The Attorney General of the United States recently wrote about the increased practice of nationwide injunctions that are being issued by district courts across this country. President Obama, during his administration, there were 20 of these issued against the administration. So far in this president's term, there have been 40 nationwide injunctions. So we're seeing this practice more and more commonly. We've got some members of the United States Supreme Court have expressed concern in written opinions about the practice. Is this something that concerns you? Is this something that you think deserves review? What are your views on this?
Well, Senator, I think it is certainly an important issue because it is an issue that's before the courts, where the Department of Justice is arguing about the propriety or impropriety of the use of the nationwide injunctions. I think in accordance with the canons of judicial conduct, it's inappropriate for me as a judicial nominee to take a position. But certainly, as the Attorney General has said, it is an important question to be resolved.
Let me just ask you about your experience. You've clerked on the circuit courts like the one that you'll be joining. You clerked at the United States Supreme Court, the White House counsel's office. I mean, is it safe to say that you're familiar with the courts of appeal, you're familiar with the operation of our federal court system, and that the job that, should you be confirmed, the job that you would be coming to is one that you have seen in practice, that you have seen as a practicing lawyer, and the docket and responsibilities are things that you are familiar with and prepared for?
Yes, Senator, I do think that is accurate. So I have been honored to have a wide breadth of experiences throughout my legal career. So as an attorney in private practice, the main work I did was writing an analysis of briefs and dispositive motions on legal issues that came before the appellate and trial courts, and that is the bread and butter of what a circuit judge does. I also have worked as an academic thinking systematically about legal issues and how different doctrines intersect to look at a more holistic view. And then I've also worked as a government attorney seeing how policies are implemented at administrative agencies on the ground. And I think the familiarity with the actual operations of government is also valuable experience.
Let me ask you about one other thing. It's recently been made public, while you were acting general counsel of the Department of Education, you requested that the Office of Legal Counsel analyze whether restrictions on federal funding being used for religious programs violated the First Amendment. And to the extent that you're permitted, can you just tell us a little bit about this work to lift restrictions, particularly on historically black colleges and universities, and what you learned about this issue when you were working on it?
Yes, Senator, sure, I'm happy to. So as you know, in 2016, the Supreme Court issued a decision called Trinity Lutheran, which said that when the government provides public programs that are open to all applicants, it cannot exclude participants or applicants on the basis of their religious status. Now, at the Department of Education, we administer the Historically Black Colleges and Universities Capital Finance Program. And that program has a number of criteria for applicants to apply for funding for capital improvements. And the way the statute is written, it excludes historically black colleges and universities that have a religious mission. And so it had seemed to me that after the Supreme Court had said that it was impermissible to exclude institutions with a religious mission from generally applicable government programs, that there was a constitutional problem there. And so I had submitted that request to the Office of Legal Counsel to get a formal opinion about whether that was permissible. And the Office of Legal Counsel ended up agreeing with the advice that there is a constitutional problem, and that if the government is providing capital financing assistance to historically black colleges and universities, it violates the First Amendment to exclude those with a religious mission.
Very good. Thank you, Mr. Chairman.